Maybe they do. I don't know.
Welcome. Welcome to Georgetown University Law Center and to tonight's panel on private security contractors. My name is Renee Doplick. I'm president of the International Law Society. Tonight's panel is brought to you in partnership with the Military Law Society and with the support of student groups Outlaw and the Global Race and Identity Project, and with the support from the Center for National Security and Law at the Law Center and the Institute of International Law and Politics located on the main campus of Georgetown University. I extend a special thank you to Tessa Marmion, Luke Whittemore of the Military Law Society, and my fellow board members, Jessica Cox, Leah Blum, and Arjun Panambalam, for their help in making tonight's event possible. Tonight's panel is part of a series of 14 events marking the 6th Annual International Law Week. A full schedule of events is available on the printed flyers. Of special interest, tomorrow in this room at the same time, there will be a panel entitled Sexual Orientation and Military Preparedness, an International Perspective. The program will feature a discussion by active and retired military personnel from Australia, Britain, Canada, and Israel about the transition to open service for gay men and lesbians in their countries, with a commentary by a retired U.S. Navy officer. This is the first international conference to examine the effects of these policy changes on military preparedness. Next, it is my pleasure to introduce tonight's moderator. We are fortunate to have him as a distinguished visitor from the judiciary in residence at the Law Center this year. He previously served as a Justice of the Constitutional Court of South Africa and the Chief Prosecutor for the United Nations International Criminal Tribunals for the former Yugoslavia and Rwanda. Please join me in welcoming tonight's moderator, Justice Goldstone.
Thank you very much, Renee, and welcome to you all to tonight's panel. Before saying anything else, I really would like to congratulate the organizers, the student organizers of this event, for the wonderful panel that they've assembled. It really is a very exciting opportunity for us all. Private security companies, private security contractors, are a relatively recent phenomenon. 10 years ago, people wouldn't really have understood what it was all about. We tend to associate them, of course, with military situations, and that's where they have reached and obtained a great deal of media attention. But, of course, they exist in the private sector as well, most commonly in the provision of private security for homes or for people. When I hear about private security contractors coming from South Africa, I think about them in the context of protecting ordinary citizens from the huge criminal violence which has been racking our country really since we became a democracy. If you talk to Mexicans, I'll think about it in terms of the private security contractors who provide security usually for wealthy people who fear being kidnapped, which has become a very common occurrence in Mexico City and elsewhere in that country. This evening we are concerned, however, with private security firms in military situations, and in particular the question of their accountability. We are privileged, as I've said, to have an eminent panel of experts who will approach the topic from various perspectives: academic, the military, human rights, lobbying for the industry, and the Department of Defense. You have in front of you the bios of each member of the panel, and I don't propose to waste valuable time by reading them at all. I propose to do no more than call upon them in turn, and when calling upon them, to remind you of their affiliation. Each member of the panel will speak for just 5 minutes in opening, and Renee is going to have warning signs when they reach 60 seconds and 30 seconds, and I would earnestly request each of them to sit down Supreme Court style in mid-sentence when the zero sign goes up. After the 30 minutes of hearing from the panel, we'll allow another 15 minutes approximately, for them to interact and to comment on each other's remarks. Thereafter, we'll use the remaining time, 30 minutes or so, for your questions and answers, and we can talk more about that as we proceed. So with no further ado, it gives me much pleasure to call on Gary Solis, Adjunct Professor at Georgetown University.
Thank you, sir. I've been asked to say a few words about PSCs from a military viewpoint. PSCs are a jus in bello fact. The traditional role of the state and its armed forces is embarked on an alteration for which IHL is not prepared itself, nor has the military establishment. Given the economic and political realities of PSCs, their presence will increase. The presence of civilian warfighters is hardly new, of course, but their numbers and expanded role is. Given the profits they generate, they'll become organized as an industry, their lobbying will become more effective, and their political influence will dwarf that of, say, Blackwater's. The international community must act to bring LOAC, Law of Armed Conflict, LOAC's core concepts of distinction, military necessity, and proportionality to PSCs. But how to do that? Well, I've got about 3 minutes, so why don't I solve that problem? A UN convention would be a start. The Western community still smarts from the 1977 protocol smackdown at the hands of the Lilliputians. The influence of the ICRC over LOAC treaty making is crippled by Western distrust, at least for the immediate future. In the eyes of some Western governments, the UN suffers the same drawbacks as Geneva, but it nevertheless remains a viable venue for broad reform of PSCs. The U.S., with the largest PSC contingent, must lead the way. Switzerland has launched an initiative to promote a marriage of PSCs and IHL. I'll mention the website address in my conclusion. The issues the U.S. should address, in my opinion, are personnel, training, control, and enforcement, issues common to any effective military unit. Personnel. Congress, as it does with the military, should enact legislation that precludes the hiring of PSCs of individuals with criminal backgrounds, that sets civilian educational minimums, and should require significant financial bonds placed by PSCs assuring their compliance. Money is always going to be the driving force for PSCs. Failure to comply must always result in significant financial penalty. Training. Congress should mandate training regimes for civilian PSCs, not only in the lawful use of weapons and ROE, but in distinction and proportionality, and IHL generally. There must be a program of trainer certification implemented by DOD. Making DOD responsible for training provides accountability for that training and precludes the formation of a new federal bureaucracy, a la the airport security industry. Control. Closely associated with enforcement, in deployed situations, operational control, in my opinion, must be exercised by the military. This doesn't imply that soldiers should be in the PSC headquarters or in its tactical operational centers or involved in PSC contracting. It does mean that no PSC can be in any tactical area of responsibility unless it is, without question, accompanying the armed forces. No more accompanying the Department of State or presence under personal contract to Union Oil. On the battlefield, there must be a clear line of authority, and that line of authority can't lead to a civilian oil executive or a GS-12 political officer. Triple Canopy must not continue to launch VIP vehicle convoys into the area of operations of the Third ID without the clearance, permission, and continuous comm with Third ID. AirScan must not continue to be free to launch helicopters into military airspace without coordinating with the military commander responsible for that airspace. There must be coordinating points in every deployed military unit, from theater command down to battalion level. An Army division, for example, has a G1 for personnel matters, a G2 for intelligence, a 3 for operational planning, and a 4 for supply. Another G section should be added to the command group for PSC liaison and coordination, led by a field-grade officer, major or above, and it must be the officer's primary duty, not additional duty. Enforcement, There should be heavy financial penalties built into any PSC contract for failure to comply with personnel training or control requirements. Cash bonds should be required before any PSC deploys. UCMJ, Uniform Code of Military Justice, jurisdiction over civilian PSC employees is already available. Implement it. Enforcement must accompany control. Yesterday, Secretary Gates issued a memorandum confirming UCMJ jurisdiction over PSCs, but limiting it to general court-martial convening authorities and giving prosecution priority to DOJ, a serious error in my view. No non-law enforcement federal agency like state should be allowed to voice a voice in the charging decision. That should be with commanders and civilian prosecutors. The website of that Swiss initiative, if anyone's interested, www.eda.admin.ch/PSC. I'll give it to you at the conclusion. We're already at a crossroads and action is called for. We must start before the opportunity for control is foreclosed by the money and political influence of PSCs. If we don't control them, they will control us.
Thank you very much, Professor Solis. We now turn to Doug Brooks, President of the International Peace Operations Association.
Thank you very much. Actually, I agree with a lot of what the previous speaker said, and I think a lot of those things have already been implemented by DoD. But my point, I guess contractors are here to stay. We need them. We want them to be in complex contingency operations. They're there because of demand, because we want them to be there. They're not new. We've had contractors doing this sort of work, or this kind of work in general, since the beginning of the Republic. Iraq, as I like to point out, is the best supported supplied military operation in history. Lots of things can be improved, but clearly we have a general model that's working. Now, there's a critical role also for these contractors in peacekeeping operations. It's not just U.S. military operations, and this is where it may get a little complex. If you go to the peacekeeping operation in Mogadishu in Somalia, today there are Burundians, there are Ugandan troops doing peacekeeping, and there's DynCorp backing them up. There's no U.S. military presence, there's no U.S. government presence. So that's a reality. We have to have a system that takes that into account. The private security contractors, the ones that actually carry the guns or do the security work, are maybe 5% of our industry. It's a small part. It's a part that gets the headlines. It's a part that everybody likes to imply is the whole industry. They're not. They're a small part of the industry, and you'll probably hear more about that later. Getting the accountability for contractors correct in complex contingency operations is crucial. And doing it in chaos where you have weak states is always going to be imperfect. We don't have perfect law here in the States. We're not going to have it, I guarantee that, in Iraq or in Mogadishu. Corporate accountability is one thing. The financial controls that were mentioned and so on, that's fairly easy to do. Certainly contractually you can hold companies accountable. That happens quite often. More difficult, I would say, is the criminal accountability and the fact that these are civilians that we're working with. Even if they're armed, they're still civilians, and we believe they should be treated as such. The other point that we should make about contractors is they're mostly locals, including security contractors. It's mostly Iraqis in Iraq. It's mostly Afghans in Afghanistan. So we have to keep that in mind. They're going to be under local law. They don't come under U.S. laws, even if they're working for the U.S. government. For the employees, they have to have a fair legal system. If you want professionals to do this kind of work, and you want them to know that they have a legal system that's going to be fair when they're being charged with the crime. Good accountability and good oversight is good for good contractors. Essentially, the companies that follow the rules are going to do better with better accountability and oversight. It weeds out the weaker firms. The industry constantly gets hammered on this issue of accountability. Okay, well, there's a limit to what we can do. From our perspective, as a trade association, we have our own code of conduct. I'll talk a bit more about that perhaps later. But we also have endorsed improvements in the U.S. governmental legal system, which we think is critical. MIJA, the Military Extraterritorial Jurisdiction Act, which is a real law that applies, and in the recent memo, it's the sort of first line of defense in terms of criminal crimes. That's something we support. We've supported the expansion of it, the improvement of it. It's all good for us from our perspective. The other key point I want to make is that transparency and accountability has importance as well. Or the transparency aspect of the accountability has importance as well in complex contingency operations. One of the things that local populations find very frustrating, and it doesn't matter whether it's Iraq or a UN operation in Congo or something, when you see a crime committed and you see no apparent accountability. media is very opaque. Nobody knows what's going on or how long it's going to take. This has been a problem, so that the Iraqis, when they see something that they perceive to be a crime, they want to see some sort of movement. They don't see anything. That's a problem. The industry code of conduct is important. We have one. It's public. It was put together by NGOs, human rights lawyers. We have a standards committee to enforce that code of conduct. We have an online complaint system. Anybody can bring a complaint based on our code of conduct to our committee. It's inclusive. We bring in the human rights committee as we update it, as we improve it. We're actually having a summit on this with NGOs in probably late July or August. We haven't set the date on that. And we have this online complaint system. We can modify the behavior to a certain extent. We can even kick firms out of our trade association, which would probably be the commercial kiss of death. But I think the other thing that has to be remembered in all this, there has to be a governmental role. Only governments can really take people, throw them in jail, or do what needs to be done from a legal criminal perspective. The industry fully supports improvements in accountability for contractors. That's all good for us. Again, we're going to be working there in the future, and the more comfortable the clients, the more likely we are to get business. Currently, in the price bill, which expands media, is in Congress and has been passed overwhelmingly. The Obama bill, I think, is in committee, which does essentially the same thing from the Senate side. So we're very supportive of those bills. Thank you.
Thank you very much indeed, Mr. Brooks. We now turn to Jim Bond, Senior Counsel for Foreign and International Law at DynCorp International, LLC.
Thanks, sir. First of all, let me thank you for inviting me here tonight, and I very much appreciate it. As a graduate of this institution, though this building wasn't here, I hate to say, when I was here, it's been wonderful to come back and see the change on campus. I'm here as one of the in-house counsel for one of the industry companies that you may have read or seen in the news. But I'll have to tell you, I've actually spent 22 years in service with the government and 3 years in private industry. So it's not a total industry perspective here. I'd like to think it's balanced. As a matter of fact, I think that's one of the problems we have right now. Industry clamors for accountability. It clamors for clarity from the government. How do you follow directions if you're not given any directions, or if the directions are so poor nobody in their right mind could possibly follow them to begin with? And that's what we're dealing with right now. Nobody more than industry would like to see the government get its act together. Contractors are not sovereign entities. We're not the policy makers. We're not the rule makers. We follow direction. And I dare say when the direction is good, we can do a pretty good job at it. I thought instead of pontificating a little bit about some of the law, what I might do is just give you a couple examples from the battlefield. And for those of you that don't know, we do some more unusual tasks. We're one of the three that you read about in the papers for the last 5 months, contractors in Iraq that provide personal protective service for the State Department. As mentioned previously, though, that's 2% of our business. Frankly, if that whole thing went away, it would be a blip on our budget. So, that's not our bread and butter. We do things like run the State Department's air wing, kill the cocaine fields in South America. Most people don't know that if the State Department was a separate country, it would have one of the 10 largest air forces in the world. So we do a lot of things that would fit in the private military company category, certainly. And here's some of the issues that we run across. And I guess my bottom line pleading here is that whoever writes the rules for the government would understand how private industry works. Because if you don't understand how it works, you cannot write effective rules on how to govern it. Not too long ago, the Joint Contracting Command Iraq-Afghanistan came out with some special clauses. And one of them was seemingly innocuous and not a bad idea. And it said contractors shall not allow one of its employees, and I'm paraphrasing here, shall not allow one of its employees to leave the country if that contractor suspects that employee has committed an offense, unless they've gotten permission from the combatant commander to let that person leave the country. in spite of the fact that my argument is I spent 21 years making sure we whisk Americans out of the country before the host country get a hold of them. I guess we have a slight reversal in U.S. policy now. That aside, how is a private contractor going to prevent an employee from leaving the country? I'm the program manager, and I am sitting in, I don't care, Monrovia, Baghdad, who cares? Guy comes in and says, boss, I've had it, I quit, I'm going home. How do I enforce that contract clause? Tackle him? Lock him in his room? You know, I'm a private contractor. I'll quote the line of one of my friends here in the audience that said, buy duct tape and duct tape him to a chair, I guess. You know, how does a contractor comply with that kind of a rule from the government? They simply can't. Another example, real-life situation. We have a contract in a certain country where we provide security services around a base. Part of the government-furnished equipment in that contract is 50 caliber machine guns. And that's a big gun, okay? It reaches out a long ways. Our program manager had the audacity to go to the government customer and try and seek some clarification on when and how we should be shooting those things. We thought it was a reasonable question to ask the government when we're supposed to be shooting a 50 caliber at the local population of a foreign country. We kind of thought maybe that was a government call to make. And what we got back was ridicule and disdain from the staff judge advocate on that base. How does a government contractor in private industry comply with anything when that's the kind of direction you get from the government? It's not that we're unwilling. We need to have some clear direction, and the policy calls need to be made by the government. I could go on about a whole lot of other things, training, standards, qualifications, oversight, criminal enforcement, and hopefully we'll get a chance to get into some of that after we're all done.
Well, thank you very much. I'll turn now to Jennifer Daskal, the Senior Counterterrorism Counsel for Human Rights Watch. Jennifer?
Thank you to Georgetown for inviting me here today and for arranging this important discussion. I wholeheartedly agree with everything that the three speakers have said before me about the importance of accountability, transparency, and clarity. My job here as a human rights lawyer is to put a bit of a human face on what we're talking about. And I'm going to start with the September 16th incident. I interviewed a number of the witnesses and victims of the September 16th incident in Turkey several weeks afterwards. For Khalaf, a 38-year-old Iraqi, September 16th started like many other sunny summer days. He put on his police uniform, a white shirt, a navy trousers, and a hat, and he headed to Baghdad's busy Nisour Square. By 7 a.m., he was out in the street, directing the flow of traffic around the square, as he does every day, or just about every day, and he spotted 4 large all-terrain vehicles with guns mounted on top. And he did what he always did. He stopped traffic, and he cleared the area for what he knew from the telltale signs of the 2 accompanying helicopters to be a security firm's convoy. Now, at first, this seemed to him to be completely normal for the totally abnormal world of Baghdad in September 2007. Convoys are common, Khalaf said to me. But this convoy made an unexpected U-turn, drove the wrong way around the one-way square, stopped, and reportedly started shooting. It was a horror movie, said Khalaf, describing the aftermath of the now notorious shootings on September 16th. And in fact, it was. When the smoke cleared, there were 17 Iraqis dead, others wounded, and the U.S. was embroiled in a foreign policy disaster, with most Iraqis equating the actions of U.S. contractors to the actions of the U.S. military. Now, while the September 16th Blackwater incident is by far the most dramatic that we know of, it's not the only incident of contractors' killings or abuse of civilians that we're aware of. A week before the September 16th incident, Blackwater guards reportedly fired into another Baghdad city street, killing 5 people. In July 2006, a triple canopy security contractor who has been accused by some of his coworkers of saying that he, quote, wanted to kill somebody today before he started the mission, reportedly fired upon civilian vehicles, damaging 2 cars and possibly causing civilian casualties. We don't know what happened to those civilians in those cars because the incident only came to light much later as the result of a wrongful termination employment lawsuit brought by the 2 employees who were fired for reporting the incident. In October 2007, a British contractor, Aranis, reportedly was escorting employees of the U.S. Army Corps of Engineers when it fired into a taxi, seriously injuring 3 Iraqis, including 1 man who lost his eye. These are just a few examples of the many incidents we know about, and there are undoubtedly many more that we don't know about. Now, just to be clear, there are many private security contractors operating in Iraq and Afghanistan and in other hotspots all around the world that have never fired at or even injured any civilian. And not all incidents in which civilians are killed or injured are necessarily unlawful. But there absolutely needs to be an adequate sorting out of lawful versus unlawful acts and accountability for those acts that are lawful. And to date, there's been relatively no accountability. No civilian contractor has been held liable for abuse of any Iraqi civilian, including contractors reportedly involved in the abuses at Abu Ghraib. And only 1 civilian contractor has been held liable for any abuse of any civilian in Afghanistan. This needs to change. I think there's 3 areas where we can start to push for, and we will hopefully start to see some change. Criminal accountability, contractual financial liability for contractors, and very importantly, and this is rarely talked about, unfortunately, compensation for victims. In 2000, the U.S. Congress expanded what's known as, it was discussed already, the Military Extraterritorial and Jurisdiction Act to cover all contractors whose activities, quote, relate to supporting the Department of Defense's mission. Unquote. And this language has led to a series of debates as to who can and who cannot be held liable for actions overseas by civilian authorities. And here I disagree with Gary Solis. I do think that civilian prosecutions are the appropriate prosecutions for most contractors. In Iraq, it's my strong belief that since state and DOD are engaged in a joint plan with integrated security, economic, and political goals, there should be no doubt that state contractors are under the Department of Defense's mission. But Secretary of State Rice has suggested otherwise, and this is reportedly causing problems for U.S. prosecutors trying to pursue the September 16th Blackwater case. Legislation, as Doug talked about, is moving through Congress slowly but surely that would expand media jurisdiction to cover all contractors operating in zones of active hostility, regardless of the contracting agency, and would also expand the number of crimes for which individuals could be held liable for. But I want to make clear that legislation expanding jurisdiction is only one step. There needs to be adequate reporting of incidents, effective investigations at or near the time of the incident, and then reporting on to the Department of Justice, none of which has happened to date. My time's up, but I do want to just raise 2 other issues that I hope we'll have a chance to come back to in the questions and answers. And one is the importance of contractual and financial liability. There was a step forward this year when Congress passed the National Defense Authorization Act, which requires new regulations regarding reporting, training, vetting, rules for the use of force, but doesn't, unfortunately, include any sort of mandate with regard to financial penalties and incentives. And then finally, I'd also hope that we'd have a chance to talk about compensation mechanisms as well. Thank you.
Thank you very much indeed. We now turn to Jeffrey Green, President of J. Green and Company. Green.
Thank you, and thanks to Georgetown for the invitation to come here and speak on behalf of some segments of the private security company industry on this very important issue. Currently, I am the D.C. representative of the Private Security Company Association of Iraq, or the PSCAI, which is a Baghdad-based trade association dedicated to advancing items of mutual interest to the private security company industry, the coalition, and the government of Iraq. Prior to my current position, I had experience with these issues as counsel to the House Armed Services Committee, where I handled contractors on the battlefield as one of my areas of responsibility. And I was also a civilian employee of the Coalition Provisional Authority in 2003 and 2004. On both Capitol Hill and with the CPA, I had the opportunity to actually witness firsthand in Iraq and Afghanistan the operations of these private security contractors. And a lot of commentators can't say that. And what I can say is that though I had only a little bit of experience seeing these folks, I was consistently impressed by the professionalism, their dedication, and their maturity. Currently, the PSCAI has over 40 members working in Iraq, and the organization considers itself an operationally focused trade group, serving as a liaison between the U.S. and Iraqi governments, other coalition governments, civilian entities, commercial organizations, the media, and between the companies themselves, and in fact, almost anyone who has an interest in private security. The association is dedicated to advancing the state of the industry and believes strongly in supporting responsible measures that promote transparency and accountability in the industry. As part of my responsibilities here in Washington, I attempt to educate officials on Capitol Hill, in the executive branch, and in the general public about the industry as it grows and matures. And this is an industry that is growing and is maturing. But typically I run across numerous misconceptions about the industry that have gained a tremendous amount of momentum. For example, the number of private security contractors in Iraq is often confused with the number of total contractor personnel. For example, during a recent hearing in the Senate, it appeared, it was actually very clear that there was confusion over the 165,000 contractors in theater versus what the PSCAI estimates is roughly 30,000 private security contractors across the spectrum of operations. According to the PSCAI's unofficial estimates, and I emphasize that they're unofficial, roughly 5,000 expatriates, including U.S. citizens, are providing private security functions, roughly 10,000 third country nationals, and the majority being Iraqi and Kurdish personnel performing these functions. And I believe that the DoD has recently come out with numbers that are even lower than that. Additionally, during that hearing, the PSC community was referred to as a band of adrenaline-filled and immature young men. In actuality, the majority of PSC personnel are former military folks with greater experience than many of the active duty forces in theater. I find it a little bit troubling to hear a suggestion that some of the panelists believe that these functions should only be limited to supporting DoD. I'd like to point out that a lot of things that these folks do in theater support not only DoD and state, they support important missions by NGOs in theater. They allow the media to move through dangerous situations and report on what's going on. They allow the host nation to take part in construction activities that are going on. So without these folks, I think the ability to conduct reconstruction could severely be hampered. Finally, I've often heard the argument, and I know we'll discuss this today, that PSCs have no accountability in Iraq. I must strongly disagree with this assertion. In fact, I would argue that there are at least 6 regimes of accountability. First, as evidenced by the release of the Secretary of Defense memorandum today, the UCMJ is currently being implemented as an accountability mechanism in theater. While the implementation is ongoing and the details are being worked out, this demonstrates an important step in consistent oversight of DoD contractors in theater, and I emphasize DoD. Second, MEJA brings a necessary legal regime to bear over contractors in support of the U.S. government. Third, as host nation law, particularly in Iraq, develops and their legal system matures, the majority of Iraqi PSCs will be covered by the laws of their own country. While we believe it's currently inappropriate to subject U.S. citizens to the developing legal system in Iraq, we feel that if and when Western-style legal due process can be guaranteed under host nation law, it may one day be an acceptable form of oversight. Fourth, the Coalition has consistently issued implementing regulations that clarify both DoD policy and statute related to the behavior of contractors and private security personnel. These fragmentation orders, or FRAGOs, are critical documents utilized at the tactical level of operations. Finally, and I'll end with this as I see my time is up, you can't underemphasize the importance of the contractual terms. This is a for-profit industry, and as those contractual terms are clarified, as the legislature, as the executive branch implement these standards and bring them to the contracts, you'll see an increase in the consistency of behavior. If it's in the contract terms, the contractors will comply because the last thing that they want to do is violate the terms of the contract. It's counter to the premise that it's a private business. With that, I'll turn it over.
Well, thank you, Mr. Green. The last panelist is Hayes Park, Senior Associate Deputy General Counsel for International Affairs at the Department of Defense.
Well, it's a pleasure to be here. I'm here in a personal capacity. I don't represent the military. I don't represent the Department of Defense. I'm purely expressing my personal views, but this is a topic that I've worked on both within the government and internationally for the last 4 or 5 years. I'm going to skip around. You can see as they were talking, I was agreeing with everything they said and scratching off things, so it made it a little bit easier for me. Let me touch on a couple things and perhaps repeat one or two. There's oftentimes this feeling that this is only something the U.S. government is doing. As several people have said, no, it's true. It's common not only with the U.S. government, it's common with all governments, particularly in overseas operations. It's most common with private industry and foreign lands. 80% of the PSC are really working mostly to protect private industry in countries where people tend to get kidnapped and things like that. NGOs use them. The International Committee of the Red Cross doesn't like to admit it, but they use private security companies. So this is not a phenomenon that is unique to the United States or to recent times, although there has been this surge, and I'll explain why in just a moment. And it is also historic. The Hessians who fought in the Revolutionary War more years ago than even before I was born were in fact a PSC. The Flying Tigers who fought in Burma were during World War II were also a PSC. So that's something that we've experienced, and we've never really had a good handle on it, perhaps as we thought we might. I want to comment just briefly on something Professor Solis mentioned, and that is the Swiss ICRC initiative on PSC. Doug Brooks and I have participated in those meetings, and they have made it clear that they do not intend to come up with new IHL treaty standards. What they intend to do is try to work with the PSCs to come up with some industry standards. And I believe, as Doug mentioned, the PSCs we have seen come to these meetings, British, American, and others, strongly support this because there are some bad apples out there, and this weeds them out. So it sets a standard, and that's very useful. There has been very good support. Now, I want to mention one other point to sort of explain the phenomenon. Can we have the slide on, please? Good. Let me give you a little bit idea of the conflict spectrum, because I'm going to show you where we are today and where we were. We are here in what are called stability operations. If you take the Iraq conflict, we began here. Major combat operations between coalition forces and the forces of Iraq. Oftentimes I hear PSC don't get prisoner of war status. This is the only place where they could get it. This was not where PSC were operating, with the exception of protecting high-value targets, some generals and some State Department personnel. For the most part, even during the conflicts in Afghanistan and Iraq, at this phase, they were being protected by active-duty Special Forces units. When we moved into the occupation phase, we became the government of Iraq. We became the policemen, the firemen, we ran the sewage system, we ran the electricity systems, had to rebuild them, we ran the roads, we were everything. Had this been a benign occupation, that is, we beat the Iraqis, they gave up, all's well, you would not have needed all these PSCs. You would have needed a lot of contractors, but not a lot of PSCs. But because it was not a benign occupation, there was an increased need for those during the insurgency. That is what really caused this surge here. I'm not so sure that I agree with Professor Solis. This is a surge that's going to continue. I think if the Iraq war ended tomorrow, you'd see a substantial decline in the use of PSC. They'll be used around the world, but not there. Right. We moved, no PLA status here, and we moved into this area, transition stability operations, which is common in many places around the world. And that's where PSC are being used, not only by us, but by industry officials and by NGOs. There's a lot been said about accountability. I fall somewhere between Ms. Daskal and Professor Solis. I happen to agree that I think the Justice Department approach is correct. There is a serious constitutional issue with the United States, with the military trying civilians before courts-martial. And there was a conscious decision within the administration, after talking with everyone, we probably should go with U.S. attorneys, as we've done in other cases under Meja. I do think there's no doubt that we need the accountability, but the whole issue is more concerned with how do we prosecute a civilian and how do we make sure that happens. So I think that is the right place. I would point out that in working on the memorandum of agreement between the Department of State and the Department of Defense in November and December, Secretary Gates did desire to have command and control over everyone in Iraq. That was something that became a bridge too far. It was a bit too hard. But that's the kind of thing, the things that are being looked at right now and worked very hard. One other point before we get into the chit-chat between panelists. I want to echo something that Jim Bonner and I said while we were talking earlier. There are a lot of PSC doing really great work in Afghanistan and Iraq. There are some bad apples out there, but the military has had its share of trials as well. I'm actually scheduled to go out and testify against a Marine Battalion commander who's being charged for failing to report murders his Marines carried out in Haditha. So this is not something unique, I'm sorry to say, to PSC, things that are in fact part of the insurgency environment and what goes on. Thank you very much.
Thank you very much indeed. What I suggest now is we go in the same order and ask for comments, and if the panelists will bear in mind that we'd like to start the Q&A promptly at 7, so we've got 17 minutes for 6 people, so it's roughly 2 and a bit minutes each. So I'm sorry to cut them short, but let's start with Professor Solis.
Doug, you mentioned in your remarks that some disciplinary procedure is available for PSCs. How many PSC companies have been kicked out?
You have to kick somebody out for it to be it's only about, we have 37 companies. None have been kicked out at this point.
Jennifer, you mentioned that there should be civilian control. How would this civilian control be achieved and by whom?
I mean, I think that those are complicated. I don't think we have a good system yet. I mean, I agree with the concerns that were raised, that there's real constitutional questions with bringing civilians before military courts-martial. And there may be some limited cases where that would be constitutionally acceptable, but I think that certainly does not, I mean, it's not going to cover the State Department contractors. It's not going to cover the USAID contractors. And it will probably only be found constitutional for a subset of the DoD contractors. And therefore, there absolutely needs to be civilian accountability. And there's a lot of difficult questions that need to be worked out to make that work effectively.
Yeah, I agree. I, too, think that civilian accountability is the primary way to go. But if you have a problem in the combat zone, there's only one person who can make that individual stay there, and that's the military. Jeffrey, you were mentioning that there is accountability in Iraq. I would ask, can you name 2 individuals who've been prosecuted in the 5 years we've been there?
I can't name individuals that have been prosecuted, but I can certainly, and I can't do it right now, but I can certainly get back a rough estimate of the number of folks who've been either released from companies under contract.
No, I mean criminal prosecutions for wrongdoing in Iraq.
My understanding I would turn that question to the prosecutors and to the DOJ and to the DOD, but what I can tell you is that the industry folks are very committed to weeding out bad apples, and they have identified folks in theater within their companies and asked them to leave.
Oh, yeah, asked to leave. Well, there's only one I can think of that's been prosecuted, however, and that's Pissarro.
There's been about 6 contractors that in Egypt. That was Afghanistan. And that was actually under the Patriot Act.
Yes, it was. But
and Afghanistan. There's been nobody in Iraq.
Nobody in Iraq. Thank you.
Thank you. Mr. Brook, any comment?
I would just add. I mean, yes, we have a trade association code of conduct, but we can't take the place of governments. A government role has to be there, and certainly on the criminality side, absolutely. I mean, we'll do what we can. I think it's sort of crazy if you don't kick somebody out of an association, then therefore it's not a working association. We also have a membership committee that keeps companies out that may get kicked out later. So that's sort of one of the points.
Jim?
I wanted to circle back to a couple, 3 maybe folks mentioned the idea of financial penalties, and don't disagree with that. How you write that quasi-judicial action into a contract could be a bit tricky. Normally you get that kind of an, and this gets back to my earlier comment that you really need somebody that's worked the private industry as well as worked the government side of the house to bridge the gap to know how to write these contracts so it'll truly accomplish the purpose you need. Typically, financial contracts typically have an award fee at the end of them. And that's where the company is evaluated on how well they do or don't do. And that's where the financial penalties come in. So to a great extent, the ability to impose a financial penalty on a contractor for noncompliance already exists and, frankly, is being exercised most every day. The contrary or the corollary to that, though, is, and the Army did a self-study called the Gansler Report, and it showed basically how incompetent all the shortcomings of the Army contracting system. And I would have to argue with you that, frankly, the Army is better than most of the rest of the government in being able to do this. And so that kind of gives you my benchmark on the rest of the government. But, we had an occasion to have a contracting officer, not from the DOD, another part of the government, that basically spent his entire career getting fired from being the contracting officer on one contract and being moved around to another one because nobody in government wanted to tackle firing a GS employee. And what he did was, when he raised so much havoc and hate and discontent and screwed up one contract bad enough, the parent agency moved him over to another contract. And so the contracting, the companies trying to comply with the contract basically had to put up with that until he got moved on. So I think there's a clear need for a lot of accountability on the part of companies. I mean, I'm a taxpayer. I want my dollars spent wisely, too. But you need that checks and balance and due process in the process. And that's just a lot easier said than done, to come up with that system.
2 seconds.
Yep.
Yeah, just real quick. Of course, the Gansler Commission Gansler report just came out on improving oversight and accountability for, is it just Army or is it DOD? I forget. But it basically took a lot of recommendations, put them into one report, and you can get it online. Gansler, Gansler.
Jennifer Daskal, any comments from you?
Sure. I guess I just want to use this time to raise the issue that I didn't get to when I talked before, which is the issue of compensation. And just to mention quickly that there's a system in the military where those injured or if there's somebody who's been killed by the military, can go and seek what are salacia payments. There's no admission of wrongdoing, but people who are injured or have property damage can go seek those payments. And there's no similar mechanism for those injured by contractors to seek some compensation. Now, we've seen in some high-profile cases, the State Department has reportedly gone to families and offered them fairly large sums of money, in fact, much larger sums of money than are offered in the salacia payments. But the availability of those dollars seems to be dependent on whether or not the incident is sufficiently high profile to induce this offer. There's civil suits that have been filed against companies. But again, that does not seem the right mechanism for ensuring that there's some sort of adequate system to ensure that there's compensation. And I would argue that companies, as part of their contract, should, and I don't know that the technicalities are the right mechanism for doing this, but should be forced to pay some upfront bond or have something written into the contract where it was clear that the contracting company would be responsible for those payments in the event of accidental damage or death.
You'll be happy to know that there's already proposed FAR rules out on that very subject. So that may be here sooner than you had thought.
Jeffrey Green?
I find it interesting on this panel that a lot of the arguments that I've heard time and again continue to come up, and my conclusion remains the same, that I think everyone here is in violent agreement that accountability is needed, clarity in the rules is needed, and what I've observed here in D.C. is watching almost a struggle on Capitol Hill, a struggle in the industry to comply, a struggle at DOD and at state to implement regulations. And if you just look at what's happened over the past few years in legislation, and the fiscal year 2008 Defense Appropriations Bill, the appropriators who handle money issues, they're not policy folks per se, but they were concerned, so they said, implement consistent standards, tell us how you're going to handle the use of firearms, talk about how you're going to judge the fitness of contractor employees, talk about the rules of engagement or rules for the use of force. On the authorization side or the policy-making side, you had two separate provisions also in fiscal year 2008 where they wanted clarity, that Congress wanted a clarity from the Armed Services Committee on the coordination of contractor movement, common databases, give us a consistent number of contractors in theater. DOD and state were required to promulgate consistent regulations. And if anybody's ever worked in the executive branch, understanding that the interagency process is an animal unto itself, can really appreciate what a task that is to bring those two very different cultures together to issue consistent standards is a real challenge. Something important happened in that bill. There's now a contract clause that directs removal or replacement of private security contract personnel who fail to comply. And I go back to my sixth accountability regime, if you want to call it that, which is the contract. Legal regimes are effective on the government side, contractual clauses, and impacting how the terms of the contract are implemented are very important on the industry side. Not that the legal side isn't, but the contract clause is where you can gain a lot of control and leverage, and I think that you'll see as DOD implements these regulations, that's just going to continue to improve. This is not an issue if you look back through, a new issue if you look back through several years of the Defense Authorization Bill, the appropriations bill, different issues introduced by Congress. You're going to see the same concerns implemented over and over and over again. What I would say to those who say we need regulation and we need oversight and accountability, I would say Congress has done a pretty good job of giving us a framework. Now we have to, as industry, support DOD in the interagency process as they implement those. Give public comment as an industry on how we believe those things should be implemented consistently and fairly. When you look at the law of war training, the interim rule that was just issued, I know that the PSCI has offered comments on that regulation. I know that several industry groups have offered comments. And I think that there's a careful consideration that you might not think is there of how these things are going to play on the contractor side and how they can actually assist the government and the executive branch in implementing these rules Congress has passed. So my last word on this would be these things are just going to take time.
Thank you. And Hayes Park.
Let me just touch on three things. Professor Solis mentioned one. Hire no one as a PSC with a criminal record. I had occasion on an official basis to review the hiring and screening processes of two PSC, Blackwater and Triple Canopy, and I can tell you that their standards are higher than the U.S. military. Their screening processes are higher than the U.S. military.
Not saying a lot there, Hayes.
And well, that's my next point, because I think it goes against yours, and that is the fact that the Army waives criminal records. So we do have to have the same standards, hopefully. Second, the issue of coordination. What we're talking about is the coordination of movement of PSC convoys, perhaps handling humanitarian supplies or what have you, from point A to point B. I had meetings both in the Pentagon and down at Moyock in North Carolina, Blackwater headquarters, on this issue right after the Fallujah bridge incident. In the initial phases, post-conflict phases in Iraq, there was, I would say, extreme hostility between the military and the PSCs for a variety of reasons. But the PSCs were saying, please help us have some sort of a fusion center. You know, if you can't tell us because of classification, Road B is going to have some attacks today, we should have some sort of center where we can go in and say, okay, we've got to get from point A to point B. If we consider 10 different routes, are there any that you think maybe are not good? Very subtly say, don't go Route 3. That's been worked out. That's one of those things where there's a lot better cooperation between the PSC and the military than there was at the start. Another point that's been touched on here is I think the real fallibility of everything that's happened over the last several years is contracting and contract officers. Contract officers go to Iraq for a 3-month tour. It takes 1 month to learn their job. Second, they're dealing with everything from widgets to toilet paper to PSC. All they see is a document in front of them, and they look through the people who bid on that, and they find the lowest bidder. That doesn't necessarily mean it's the best way to go. There was one case where there was an Iraqi PSC hired under one of these contracts who totally failed in meeting the contract terms. The contract was severed, he was fired, he moved next door, changed the name of his firm, rebid, was the lowest bidder again, and got another contract. So we need some oversight on how we hire these people, and that is a real critical point. I'll stop there.
Thank you very much. Well, that's a great panel. I must say, I've never had such military precision and timing from a panel. I wish more academics would take note of the of this. So now I think we should open it for questions. Please, if you'll introduce yourself by name and affiliation, and if you want to put a question to a member of the panel, please do so, or members. Or we're also welcome to address questions to the whole panel. And if you would put your questions from the standing microphone that's in front.
Hi. I just wanted to thank you all again for being here and engaging with us on this discussion. My question is...
And your name first.
Oh, sorry, Margaret Price-Towski. My question is very specific to UCMJ jurisdiction. And I'm wondering specifically why it is that there's only seems to be jurisdiction for contractors that are contracted with the DoD. I'm wondering basically, is this an assumption we're making? Is this a choice that the government is making? Or is this related to the specific provision in the UCMJ that says you must be serving with or accompanying the armed forces? And if so, my understanding from reading the Manual for Courts Martial and the related case law is that the test does not necessarily require that you have a contract with the armed forces, but that you be merely directly connected to the armed forces. And so I just wondered if I'm reading the case law wrong, or if because it seemed to be something that the panelists said over and over again, that it only seems to apply to DoD contractors.
Well, I think I'll take the first stab at that, and I would call it more of a preference by the U.S. Supreme Court than by DoD. Hayes, I think, be able to jump in here on some of the cases coming out of the Vietnam era in particular, limited that jurisdiction. I'll throw one wrinkle into the UCMJ jurisdiction that hasn't been mentioned, and that is, let's say you had a Russian, and believe me, there's plenty of them over there, or take your other favorite country, that are contracting to DoD or somebody else. If you it's difficult to politically American before a UC martial. Think of putting a Russian or Jordanian entity before a military court martial. I think you get into a whole obvious new world of dynamics on that one.
There was a Vietnam case entitled United States versus Averett, in which Averett was convicted of theft of material from a motor transport pool. And when it got up to the Court of Appeals for the Armed Forces, or as it was known then, the Court of Military Appeals, that the military lacked jurisdiction except in cases of declared war. And, of course, there hasn't been a declared war since October 1945, and we're unlikely to see another declaration of war. So they effectively cut off all prosecution of civilians. There were 6 convicted civilians by the Marine Corps in Vietnam. I don't know how many by the Army. But that was a dead letter until there was an amendment to the Uniform Code of Military Justice Jurisdictional Article 2, which provides that civilians who are accompanying the armed forces may be tried by court-martial. That was a dead letter until there was yet another amendment. I'm not sure, Hayes, how that amendment changed things. But now there is obviously jurisdiction. I say obviously. There is now jurisdiction over civilians who are with the armed forces, not if they're with the Department of State. And that's what I meant when I said anybody, what I didn't say but meant to say was that anybody who is in country should be considered as being with the armed forces so that there would be UCMJ jurisdiction if it would become necessary. But as Hayes and others have pointed out, there are going to be a lot of constitutional issues on the prosecution of civilians by a military court.
There was the amendment of 2 or 3 years ago to Article 2, Paragraph 10, to include contingency operations and try and get around the previous Supreme Court decision. I've been one of those who said, look, the whole thing has changed. The situation has changed. As Gary just pointed out, we've only declared war 5 times in our history, and the last one was World War II. We've done a few other skirmishes since that time. And I felt like, go ahead and find a really solid case and take it to trial and see if you don't get a different opinion from a different court. That wasn't done, and we did have the lack of success in Vietnam. We did have this amendment in Article 2, Paragraph 10, and part of the reason for us moving towards this memorandum of agreement between the Department of Defense and Department of State was what I refer to in the military as unity of command. There can only be one commander in the theater, and this is something Professor Solis also referred to. That was the desire of the Secretary of Defense. Let us just say that the other agency involved in this, which is a major employer of PSC, did not like that. And particularly, not so much for the PSC, but did not like the idea of their employees going before a court-martial, which is why we also kind of fell back on the MEJA issue. The memorandum issued by Secretary Gates yesterday basically makes it clear that those people those contractors working for the Department of Defense, we will look to possible UCMJ use. Those other cases will probably go before a U.S. attorney. Now, let me respond to something else that was asked earlier. How are we going to do that when we have, let's say we have a Farm Bureau or Agriculture Department employee who commits an act of murder of a U.S. citizen in Iraq, not an Iraqi citizen where they might become subject to Iraqi jurisdiction. Part of the issue that we discussed in November and December in trying to develop this memorandum of agreement was who's going to do all this? We would have to have a contingent of 50 or so FBI agents in Iraq and possibly some U.S. attorney representation. That brings in another agency, and that's another one of those details to be developed.
Can I just one factor into this? What is the position, or what should the position be, with regard to criminal conduct by employees of PSCs who are not Americans? I mean, I know there's a substantial number of South Africans, for example. I think some very inappropriate in that position.
MEJA, the way it's written is very interesting. It covers all employees of contractors or subcontractors of the U.S. government except for local nationals. So the South Africans, if they're working under U.S. contractor, subcontractor, or whatever, they'd still be under U.S. law. Now, MEJA has a little trap door that says, okay, if South Africa wants to prosecute these people for the crime, then MEJA's set aside, and the South Africans are allowed to.
But there could be extradition.
Apparently.
There could, but it's never happened.
Mm-hmm. Right. There was some other question? Mm-hmm.
Hi, I'm Aaron Young. I'd be interested to know why each of you would think that, I understand that we're not going to stop using PSCs tomorrow, but why is the continued use and even expansion of the industry seemingly a foregone conclusion here? And is it a good thing that civilian or non-DOD civilian government agencies are conducting military-style operations in foreign countries?
I don't think it's a good thing, but it is an inevitable thing, and it is going to expand. And the reason for that, Aaron, is because of the drawdown on U.S. forces. We simply don't have enough personnel to do what we used to do. We used to send Marines and soldiers to mess duty for a month. Well, those days are all long gone. Many of the essential missions of the military simply can't be done if we have to rely purely on military personnel. We have to contract those out. And the worldwide economics are such that defense budgets are, instead of expanding, well, one country accepted, are going to be contracting. And I think it is inevitable, not only for the U.S., by the way, as has been pointed out, this is happening with all countries all over the world, are going to turn more and more to PSCs to conduct operations.
I'd put it in this way. We have a more professional military than we've ever had before, and we actually expect our military to win wars in days or weeks, not years. And to do that, to get to that level of training and proficiency and so on, a lot of the ancillary tasks are handed out to the private sector with actually very cost-effective results. There's a lot of civilian operations, a lot of the reconstruction in Iraq. You don't want GIs protecting, Bechtel as they rebuild a power plant or something. It's a private operation. You might as well have private security for it. Private security is normal. We have 3 times as many private security police in the U.S. as we have cops. Every country has more private security because you don't want police or you don't want military doing all this stuff. And then ultimately, I mean, even the UN, if you go to a UN operation, their headquarters, their warehouses, everything may be protected by private security. That allows the blue helmets, the peacekeepers, to actually go and enforce the mandate rather than just protecting things. So I think there's a lot of reasons. I think we're finding that it's cost effective. It's the use of these contractors is revolutionizing peacekeeping. So I think that's why we're going in that direction.
I think there is an interesting subset of your question, which is something that's being looked at by what's called the Commission on Wartime Contracting, which was set up as the as part of the National Defense Authorization Act that was signed into law in January, which is the question of, are there certain functions which are inherently governmental, which contractors shouldn't take on? And I don't have an answer to that. I think it's important. I mean, I think it's a really important question to look at. And I think that, I mean, some of the possible areas that I would throw out would be contractors providing security for legitimate military targets or running military convoys. I would argue potentially fall into that category of inherently governmental and should not be taken on by private security companies. But this is something that's going to be looked at for the next, I mean, it's a long process. It's 2 years, and I think will be an ongoing debate about what falls into that category of inherently governmental, and are there certain functions that security companies should not take on. I agree with the other panelists that this is something that's here to stay, and there are important roles that security contractors can and should play, but there needs to be an effective accountability regime to go along with that.
Well, I think I'll finally disagree with one thing Jennifer said, but and you know, we'll all draw the line in the sand differently on what is and is not inherently governmental. I couldn't agree more that that decision needs to be made, but you know, again, it's a policy call, so get 10 people in the room and you can get 10 different answers. The one thing I was going to mention that I haven't heard anybody mention before is one of the things that your private contractors bring to the table, and it's whether it's feeding the guys or, you know, delivering the water or providing security, is I'll term it scalability. And, you know, you need 10,000 whatever truck drivers instantly. The only way any government, and you know, we provide services to innumerable governments. We're far from solely contracting to the U.S. in support of what, you know, everybody else has been saying. This is not a U.S. phenomenon solely. But if you need an instant growth in capability, that would be more than you want to pay in taxes in order to have that capability on the shelf within the government. And so I take the Rwandan case, mid-'90s, was it, when the Army went in and provided the water supply that helped ease the crisis there. At that time, there was probably no other organization on the face of the earth that could have gone in that quickly, that efficiently, with that much capability to starve off that crisis. I would argue today there's innumerable companies that could go do that. And as a result, you and I and every other taxpayer in every other country don't have to pay for that capability sitting on the shelf to be able to go do that. Something like that needs to be done. You issue out a contract and they go do it.
You can make any comments?
Let me. Well, I think Hayes and I are running out of good arguments here. Most of them have been made, but I would agree about the drawdown and force structure. I mean, I think there's an affirmative decision that when the military is paying for an asset, they want it to be a operationally focused combat asset. You know, your grandfather peeling potatoes is no longer cost effective, as Jim said. You know, when we don't need that asset, when we don't need private security contractors, let's not be paying for them. When we don't need folks providing meal services and other general service contract type issues, let's not be paying for them. And I think this is a good illustration in Aaron's question how that line often gets blurred between what's contractor, what's private security contractor, and I think the two can kind of blend together. But I think the answer is the same as far as scalability, as Jim put it so well.
Yeah, this actually goes back to the early 90s, the whole idea of reinventing government or outsourcing, emphasis on outsourcing. And I think it was one of those things is be careful what you ask for, that had people perhaps seen what we were experiencing in Iraq and the need for so many PSC, they might have rethought what should and should not be done. As for the cooking, I can tell you the cooking has improved. The average Marine coming out of his tour in Vietnam had lost 20 pounds. The average soldier coming out of Iraq today has gained 20 pounds. So that speaks well for the food. 3 years ago, the Government Accounting Office conducted an investigation of PSC in Iraq, and they came out with a very profound conclusion. You wouldn't need PSC if you had a larger military. It's good. And they're doing another one now because they probably figured 3 years was time to take another look at it. It's just one of those realities that we have there, in part, as I pointed out, because we're there working now out of the occupation phase, but now working with the Iraqi government on many things that we did not have a military constructed to do.
And I just want to add one point to what Hayes said about that report. Though GAO may have said your military isn't big enough, you have to keep in mind that private security functions are purely defensive, static security, convoy security. They are prohibited by law from conducting offensive combat operations. I don't think you'd find a member of our association, Doug's association, any company who would disagree with that. They're not in the business of offensive operations.
I wrote our own company's rules for the use of force policy, and I can't tell you how many times in big, bold letter that concept is in there. It is self-defense only, and that's it. Mm-hmm.
I'm Sasha Volokh. I'm a professor here at Georgetown. I have a follow-up to the previous question, which I don't know if maybe the previous question was trying to be more radical than the answer that you were giving. But regardless, I will convey a view which I don't know that I agree with completely, but I have some sympathy to it. Basically the answer to why do we have so many private military contractors was of the form, we need them because we couldn't do it if we had we couldn't do it with our military alone, or they do the same thing for cheaper. If we tried to do it with our own military, it would be prohibitively expensive. Now, in the minds of some, that's actually a plus. That is when we're talking about privatizing garbage collection, doing the same thing for cheaper or doing better for the same money is an unambiguous benefit, because who doesn't want more efficient garbage collection? But there are those who argue that more efficient warfighting is actually a negative, and that you should want militaries to not be so efficient, because that means that with the same tax money, the United States can wage more wars. My research, a lot of my research has been on private prisons, and there are some, not many, but who argue that even if you could show that private prisons are unambiguously more efficient, lower cost, higher quality, that actually is an argument against using them, because that means that we'd lock up more nonviolent drug offenders in the war on drugs, and that would be incredibly evil. So it seems that so this argument in the context of private military companies can be rephrased as, if you think that the United States military is more of a force for evil than for good in the world, then actually prohibiting or scaling back on private military contractors would require that more things be done more publicly, with not only with more congressional involvement, but also with more involvement of the military itself, that people, kids coming back in body bags have a different emotional salience than contractors that are dead. And whether you think that's good or bad, maybe it's wrong that body bags have this great salience, and that it's better that they be contractors. But it seems that this is, you can't extricate questions of whether it's good to have private contractors from the underlying moral issue of whether it's good or bad to have the U.S. government doing all of this stuff. And if we couldn't have been able to wage the Iraq War without contractors, some people would argue that that would have been better for all concerned. So in any event, I'm just relaying this. I have some sympathy with it, but not total. And I was just wondering whether you have comments on that.
Can I weigh in on that real quick? Yeah, you cannot do Iraq, you cannot do Afghanistan, you cannot do Kosovo, you cannot do Congo, you cannot do Darfur, you cannot do Sierra Leone, you cannot do the next Rwanda. I think you're going to have these things. You may like the operation, you may not like the operation. The companies don't make that choice. All they do is carry out the policy and try and make it better.
I'd go a step further. I wish we could decommission the military. I'd much rather us be, buying food in schools. And my personal view is the largest national security threats facing this country is probably poverty, corruption, and lack of education. Let's face it, if you didn't have those three in Sudan and Afghanistan and everywhere else, we probably wouldn't be where we are. I just don't know how we can have a safe and secure world in which to work on poverty, corruption, and lack of education without having standing militaries to keep some of the folks in check that would prevent you from making headway on the more humanitarian goals.
2 points on it. I'm not so sure that the size of the military
and contemplating using PSC was something as a factor in the decision to go into Iraq in 2003. The arguments made by the military were, we have the ability to defeat Iraq within 30 days. There wasn't, and I think you'll probably see some of this in some of the books coming out very soon, there wasn't a heck of a lot of planning for what happens after that. And this idea of a very hostile insurgent occupation was what brought the PSCs into the equation, rather than, gee, did we look far enough down the line. On the issue of body bags, I unfortunately have heard people say both. Well, it's an all-volunteer force, they get killed tough. I take exception to that. I also, as I said, had some experience in working with the Fallujah Bridge incident involving the Blackwater employees. And I will tell you, I think it had as much effect on the American psyche as had it been 3 servicemen. So I don't like to, war is a tough thing. And I'm not so sure that the American public has sort of said, well, it's just a contractor. Whichever, it's a tragedy to the people it's happened to. And I don't know that they really made that distinction between a PSC who's died in action and, in fact, I think people are shocked when they hear the number of PSC and other contractors who died in Iraq and soldiers.
Okay. Next question.
Norman Penelovich, thank you very much for all of your comments. I just have a question kind of directly related to the accountability of the contractors and a mechanism for that. Since the employees are contract employees, how do any of you feel about including as part of their contract that they'll fall under military hierarchy, military jurisdiction, they'll answer to chain of command? And I understand that there are operational issues in the field on that, but that would that allow for greater oversight and for as you were discussing, all of you were discussing, how there is an ambiguous standard of kind of what the law is in Order 17 and all those things, and would that allow for more direct oversight and for more potential for criminal prosecution for wrongdoing?
Let me jump in, because I have been addressing that very question with some of our employees. There's a difference between acknowledging something that exists and creating jurisdiction. We can put anything in our employment contracts with our employees that we want, but that does not add to or take away from a nation's court's jurisdiction. The jurisdiction is established by that nation's parliament, Congress, whatever, or perhaps if influenced by international agreements, none of which the contractors have, nor should they have, a whole lot to do with. We had CENTCOM right now is requiring all DoD contractors in Afghanistan to sign an agreement or sign an acknowledgement that they are subject to UCMJ jurisdiction, which, you know, we've talked about, and I don't think we'll ever. I personally don't think you'll ever see it happen, but you know, that's my personal opinion. And they also have to sign an acknowledgement that they may be subject to Afghani, in this particular case, Afghani law. And I don't think that's going to happen either. If for no other reason, there's a status of forces agreement with Afghanistan that sets forth the jurisdiction. And as I told our employees to quit being sea lawyers and go back to work, what you sign in that acknowledgement isn't going to change the SOFA agreement. You know, that's what's going to govern jurisdiction. So I don't think there's anything wrong with having them acknowledge in their employment contracts that they should be accountable, and they could be accountable in whatever the mechanism is, but it isn't going to change the jurisdiction.
Any further questions?
Hi, I'm Greg Kloponis, and thanks to the panel. This is of intense interest to me because I've been in Iraq since 2004, and I've had a sort of a foot in both gardens. I was a training officer on the Minsticky staff, and then later I was advisor to a private security contracting company. And I just want to make a couple of points, and I do have a sort of a top-down question. One of them was we were talking about MEJA and the precedents for criminal prosecution. And I just happened to be looking at the CRS report to Congress, and there was, in February of 2007, apparently, somebody was criminally prosecuted for child porn. So to the extent that that may set a precedent, I don't know. I just wanted to bring that up because I think we're struggling. There was a couple of comments that I wrote down by Mr. Bond and Mr. Parks, and it's an evolving industry, and it was an ad hoc sort of, what do we do now? Let's bring in private security contractors. And as such, it's an evolving industry. It's still very fragmented, so there's lots of disconnects. But what I do see over there is a very, very adversarial relationship between the contracting community in general and the federal government. And it's sort of at the mid-level, at the 06 and sort of 04 action officer level. And what I see there, and I spent last summer as an advisor simply sorting out these sort of contractual issues, try to interpret the FAR, interpreting emails back and forth from action officers and CORs, who contract officers' representatives, who weren't trained, who didn't understand law, who didn't understand the commercial implications of some of the things they were doing. And so I guess what I'm getting at here is there some effort by the U.S. government and this community to come together at a top level and sort these things out? Because I've been over there. I've dealt with every PSC that's over there, and there are a lot of good people. And I stand behind the comments of Mr. Green, Mr. Bond, absolutely. And there's a lot of good people on the government side. But the government, on the other hand, has issues with the turnover, contracting officers turnover. They've been extended now 4 months. So the problem is that when there are non-performing contractors or problems with certain individuals, it's anecdotal. And by the time the mechanisms gear up to try to do something about it, that individual, that contracting officer is gone. And again, that person, that's just one of 100 things that person's doing. So it tends to perpetuate. But on the balance, the folks over there are trying to do a good job, and they are doing a very good job, and they are professionals. But is there some recognition by the U.S. government and obviously PSCAI, I know I've dealt with those folks, to try to come together at that level and then maybe at this level, Mr. Green, to sort of sort these issues out? Thank you very much.
Well, I think certainly the PSCAI has been open and trying to initiate in a dialogue. Just in January, the Deputy Secretary of Defense, Deputy Secretary of State held an open dialogue with industry leaders and some of the trade associations to talk about these issues. And what I can say is it's an evolving process. Just as the industry is growing and maturing, so are efforts like this to bring in industry to participate in this top-down process. I think that a key point that you mentioned, and it's kind of that other element that I've alluded to, which is the economics of the industry, pressure, consolidation, bad actors are going to be weeded out. It's going to be in no one's best interest not to comply with the rules and regulations as they flow forward. And I think that competition with the industry will help with the accountability issues and will encourage folks to get involved at that higher level.
In Vietnam, we had 80,000 contractors at peak, and the contract officers were going for 1 year at a time. And the complaint of the companies was that the contract officers were just learning the job after a year, and then they're going home, and now we're sending them for 3 or 4 months. So, yeah, it's been a problem. It's been one of the big complaints of our companies, and that I've testified in Congress on this, saying we need better oversight, we need people staying there longer, and so on. If I could just touch your other point about the adversarial relationship, we have a IPOA as a separate 501c3 that we've set up called Peace Operations Institute. And their first major report was exactly on this issue, and it was done by Patrick Cullen and Peter Weinberger, and it basically says, it did a fairly comprehensive study in a very short time, but it says, there needs to be a partnership on this, not an adversarial relationship. Essentially, a lot of these things can be sorted out without having to go to courts or whatever else, and that's the way it should be done, especially for complex contingency operations.
As a result of the January meeting that was hosted at the Pentagon by DepSec England, in which Deputy Secretary of State Negroponte also participated, there was, 30, 40 companies, does that sound about right, present there. Ours were 2 of them, obviously. And since then, there's actually been a fair amount of outreach to the industry. I wrote a letter today for Senator Lieberman asking about certain items. Deputy Assistant Secretary Bell, I think is the right title for him, has met with private industry and has solicited their comments. Through Doug's organization, the IPOA, we've got a subcommittee preparing some comments. Another industry group here in town, Professional Services Council, has been specifically solicited by DOD and Department of State and USAID to provide industry comment to them so that they could get a better handle on how to work together. So I think the answer is finally yes, but it's a long time coming.
One last question.
Hi, my name's Tara Lee. I'm an attorney that's in private practice here in the area, and I want to ask you guys all a question that has to do with the civil system of accountability, because everybody's always talking about the criminal accountability for contractors, but I'm in the camp that sees the likely prosecutions to be a very small number compared to the deluge of civil lawsuits that we're going to continue to see for years. So if I could turn your attention for a second to the framework of civil accountability, recognizing, by the way, that from the victim's perspective, I think oftentimes, particularly people in foreign countries, to them it doesn't make a great deal of difference whether the accountability came in a civil court or a criminal court. To them, it's a judgment and it's an amount of redress. So within the context of accountability, I think it was Jennifer who noted that we have contractors out there who are appearing to the people in the foreign countries to be performing a sovereign role. I also think, to some extent, they're at the very least doing the work and the will of the sovereign, setting aside any specific discussions about whether they're offensive or defensive. Does anybody have any thoughts on the appropriateness of potentially extending them sovereign-type immunities if we're going to continue to use them in those functions? This is coming up in a couple of appellate cases in the next couple months, and you guys are all sort of a very diverse panel of experts. I'd be really interested to hear if any of you think that's an appropriate idea, really dumb idea, any thoughts that you might have.
I have a very prejudiced point of view on that one, so I'll let somebody else go first.
I mean, my answer is I don't think it's an appropriate idea. I think in certain cases there may be appropriate times where that theory of immunity would apply, but I think they would have to be extremely far and few between. And contractors they're not the government. They're operating independently, and there should be a mechanism of civil liability open. Having said that, I don't think it's the most effective way I don't think having civil liability as your compensation scheme or your accountability scheme is an effective or necessarily an appropriate mechanism for doing so. I think that there should be criminal liability. A small subset of victims, but the victims and witnesses that I talked to for the September 16th shooting made it very clear that their main interest was criminal accountability, much more so than getting any sort of compensation. And if they had a choice, they would have preferred to see that than actually getting money in their hands. At least some of them, not all of them. And secondly, I think that it depends on the vagaries of connecting the particular victim to a particular lawyer who's willing to bring the suit. It's not a comprehensive system for actually dealing with the problems of compensation. So I don't think it's the best way forward, but I also don't think that companies who are operating in non-sovereign roles should be getting immunity for their actions.
My only concern is that you're still able to do the operation. If you need to have these companies supporting, whether it's peacekeepers, U.S. military, whatever. So, however it's done, and I think there's a number of ways you could arrange this. You just have to make it so that you can still have companies doing this sort of thing. That know that the companies aren't going to back out for the.
And if I can just add one footnote, it's under U.S. law, as I said before in response to an earlier question. Contractors cannot perform what are inherently governmental functions. And if that's the case, then it seems to me that contractors should also not get quasi-sovereign immunity as well.
Let me use a simple case and then a real-life case going on in Iraq right now. Under most status of forces agreements, which is basically a treaty between the U.S. and the country wherever the U.S. troops are stationed, in a nutshell, let's say under that agreement, which is typical, the active duty members are immune from host nation criminal prosecution for any acts that are performed in the course of their official duties. That's pretty standard. What's that mean? That means the Marine private standing guard at the front gate tackles one of the locals trying to break into the base. and prevents him from breaking into the base, which is what he's there for. Okay, can he be criminally prosecuted for assault and battery against that host nation citizen? The answer is no. He was doing an act in the course of his official duties as instructed. He is immune from host nation prosecution. He would detain that person. They'd call the sergeant guard, the local police come out, pick the guy up. All right. Question for you. Because of the drawdown in forces, we now hire Umpty Squat to be guarding that base. The guard is going to have to either have the same immunity from local prosecution, or he ain't going to stop the guy from breaking into the base. Why should he? Let's see, go out and do my job and get thrown in jail. I want to sign up for that job. So, to some extent, immunity is going to have to inure to the contractor. Now, the question becomes, that's easy, you tackle the guy. That's different than shooting up people, And so we're talking about degrees, but it's the same concept. If we're going to have contractors performing missions, there's going to have to be some way where, one, you can get people to actually volunteer to go do it, and two, some method where the cost of them volunteering isn't going to make you and I broke paying taxes. So my argument is, yes, there has to be immunity of some type. What I see coming is the government is attempting to shift all of its risk to contractors without making any compensation for that shifting of risk. And I think the civil liabilities that are going to be imposed upon contractors, the case in point I mentioned earlier, how do you prevent an employee from leaving the country without facing a civil lawsuit for false imprisonment? The answer is easy. You don't prevent him from leaving the country. And so that, to me, is perhaps the most significant unaddressed issue yet to be resolved between the government and its contracting folks.
Right. Well, on that note, I think we must bring these proceedings to a close. It's been a great pleasure to moderate this great panel. I've learned one thing, and that is I think that there's a lot to be done in educating the public in the United States and elsewhere. I think I read a fair amount, and I've learned a great deal. And I think there's huge ignorance about the issues that have been discussed this evening. So I'd ask you please to join me in warmly thanking the panel and invite you to join us for something to drink and a snack. Thank you very much. Very good.